Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. For the members of the public who are following the high-profile civil case of Steve Goncalves et al. Versus Washington State University, there's been some discussion as to where exactly is Washington State University's response to the plaintiffs' February 27th motion to strike the defense's answer. If this motion were granted, their pleading would be stricken from the record. So in looking at the docket today, and it's after hours March 10th, 2026, there's no response as of yet from WSU. And some are wondering, is WSU rolling over? Are they not going to respond? It appears that the answer is not due as of yet. Under the local rules of court, there's something called a noting date in the Western District. That establishes two things. First, it indicates what is the earliest date for the court to properly entertain the motion, for the motion to be ripe for the court's consideration. And the second is it sets forth the schedule for the briefings. Regarding the noting date, if you look at page 1 of the motion to strike, you will see a noting date of March 20th, 2026. That seems to suggest very strongly this is a 21-day motion as opposed to a 14-day or a 28-day motion, because 21 days from the date of filing of February 27th is March 20th, the noting date that the plaintiffs have listed. With regard to a 21-day motion, the response from the other side is due 15 days after the filing date. Then any reply, that would be the last item in the sequence, the last briefing in the briefings on this motion to strike, is due on the noting date, which would be on or before March 20th. Once all the briefings are in, the court will typically do one of three things. Either the court's going to go ahead and rule on the papers based on the motion, response, reply, and the declarations that are filed in support of the same. Or the court could ask for additional briefings. The court could look at the documents and say there's a specific area of the law, specific point of law, or there's a specific fact that's in either the plaintiff's motion, the defense's response, the plaintiff's reply, that the court would like to see some further briefings on, and will ask the parties to do so. And that would be in the form of an order that would appear on the docket. Or third, the court could go ahead and schedule oral argument. The plaintiffs have asked for that, and that's a hearing where both sides would come before the court and one last time before the court rules attempt to convince the court, if it's the plaintiff, that the motion should be granted, if it's the defense, that the motion should be denied, and thereafter a ruling will come down. So we're going to continue to keep you posted as to when WSU's response is filed. We are anticipating a strong opposition to this motion, attempting to convince the court not to grant it. And then when the reply is filed, the reply replies to the response, just like the response replies to the motion. And ultimately, what the court's ruling will be. Until next time, this is Kathy. Thank you for joining us here today.